I am Beate Sjåfjell, and it is my pleasure to present this work, which is a part of my broader research project on corporate sustainability law. Corporate boards are now more than ever between a rock and a hard place. The metaphorical rock refers to sustainability requirements in legislation, in internationally endorsed social norms, and society's expectation that business shall be a part of the transition towards sustainability, towards a safe and just world. The hard place in the a rock and a hard place metaphor refers to the increasingly outdated financial markets-based law and economics inspired social norm of shareholder primacy. This social norm expects boards to concentrate only on maximizing returns to shareholders and everything else be damned. This is contrary to law, including company law, yet it is such a pervasive social norm that it has become a legal myth. In this presentation, I will now move on to speak about what the European Union, the EU, as a matter of treaty obligations actually are meant to be aiming for, and what we as peoples and societies in general want and need. Then I will give a brief overview of what the EU is doing, the unprecedented developments that we've seen over the last years, and then how vested interests are now working to fuck it up. The latest news shows that this is no longer just about the Omnibus proposals to simplify legislation. It goes beyond that. This gives the backdrop to discuss the evolving regulatory ecology, as I call it in my work, of the duties of the board, and how the board can get out of the squeeze between a rock and a hard place and actually do its job properly. Working towards sustainability, which I together with colleagues conceptualize as a safe and just world, is a necessary aim, not only because the alternative is an ever bleaker development, an ever more certain path towards a very uncertain future for all of us, but also because a safe and just world is one where we can see intergenerational, intersectional, interspecies flourishing, justice, and possibilities for all of us. This is not only a policy choice. The EU treaties set out legal duties for the EU institutions with knock-on effects for the member states, notably in Articles 3.3 and 3.5 of the Treaty on European Union, where it is set out that the EU shall work for the sustainable development of Europe, mentioning, among other things, a social market economy, a high level of protection and improvement of the quality of the environment, and that the EU shall contribute to peace, security, the sustainable development of the earth, solidarity and mutual respect among peoples, free and fair trade, eradication of poverty, and the protection of human rights. These are EU treaty duties that the institutions must work towards. We who work in this field have said for years, even decades now, that legislative reform for corporate sustainability is needed. And by corporate sustainability, I mean the contribution of business to sustainability, to a safe and just world for all. Corporate decision makers have increasingly joined the call for legislative intervention to mitigate the extreme legal uncertainty that they now face and to create a level playing field for the increasing number of sustainability-oriented businesses. The EU has over the last few years shown an unprecedented willingness to finally follow up on its own treaty obligations, to do what is necessary to ensure that business contribute to sustainability, which in turn is necessary to achieve sustainability. The EU's initiatives on sustainable finance, on circular economy, and sustainable corporate governance have led to important changes in the regulatory framework for business. These include conceptualizing sustainability risks as a legal concept, including that in the legislation, rules on mitigating greenwashing and more broadly sustainability washing, corporate sustainability rules that can actually move us beyond the irrelevant and unreliable reporting we've seen over the last decades. Actually getting into place in 2024, the Eco Design for Sustainable Products regulation, which has the potential to change business models from within, with a commission targeting extremely unsustainable sectors such as fast fashion amongst its top priorities. Also in 2024, and in spite of much resistance and with impressive mobilization from civil society, business itself, policymakers and academia, the Corporate Sustainability Due Diligence Directive was adopted. This isn't enough, and there are plenty of aspects where further work is needed, but what a great start. And yet, now, instead of celebrating these beginnings and finding ways how to strengthen the regulatory framework, which has a number of weaknesses as I've presented on previously, vested interests and shareholder primacy proponents are lobbying intensively to reverse the progress that has been made. The issue is no longer just the misinformed and confused omnibus proposals to simplify legislation, including the Corporate Sustainability Reporting Directive and its European Sustainability Reporting Standards and the Corporate Sustainability Due Diligence Directive. These omnibus proposals have received well-founded criticism from business, finance, and civil society organizations as well as academics. I'm just showing two of many examples on the slide here. But now, riding on a wave of dangerous populism, Germany and France are apparently proposing to ditch the Corporate Sustainability Due Diligence Directive completely. This is not only against common sense, as it increases liability risk for business and reinforces patterns of exploitation of people, destruction of the environment, and undermining of economic and governance basis for well-functioning societies. It is a violation of these two important EU countries' treaty duties. Member states of the EU have a duty of loyalty according to Article 4.3 of the Treaty on European Union. This provision requires sincere cooperation and working to facilitate the achievement of the EU's tasks and refrain from any measure which could jeopardize the achievement of the EU's objectives. These include, as I've mentioned, a sustainable development in Europe and contributing to a sustainable development in the world. Working towards sustainability is not just the only sensible policy choice. It is also a legal duty, and by fucking this up, as they seem ready to do now, member states risk being held liable in courts of justice as well in the courts of public opinion. With this extreme uncertainty created by the omnibus proposals and other pushback, how can boards get out of this rock and a hard place squeeze? What I present here draws on my ongoing work in corporate sustainability law. For those who haven't attended previous presentations, I can briefly mention that the theoretical and analytical framework of corporate sustainability law integrates the feminist regulatory ecology approach, which Sarah Cornell and I have developed together. If you're new to this and interested in learning more, I refer you to the readings. So, for a board, a first step is to recognize that the regulatory framework for their duties is evolving rapidly. The second step is to follow up on this recognition and execute the job of the board properly. Boards can no longer rely on previously established legal starting points, such as those that a parent company is not responsible for harm done by its subsidiaries and that a lead company can contract its way out of any responsibility for what happens down in the global value chains. The international trend of lawsuits against companies and their boards is demonstrating rising liability risks for boards relying on these outdated perceptions. Whatever the outcome of the omnibus proposals and other pushback, the evolution of what I have conceptualized as corporate sustainability law cannot simply be reversed. The integration in EU corporate sustainability legislation of, for example, the OECD guidelines for multinational enterprises on responsible business conduct and the UN guiding principles for business and human rights has strengthened these internationally endorsed sets of social norms. Even if EU policymakers were to commit the unconscionable act of repealing some of this legislation, it won't unring the bells that have been rung. This means, notably, that corporate sustainability due diligence is an evolving horizontal norm. It is what companies increasingly are expected to undertake, whether they fall within the scope of current and possibly future revised legislation or not. Boards that act based on lack of information because corporate sustainability due diligence hasn't been carried out will find themselves in a very precarious situation if the company or the board members themselves are sued. The mitigation of corporate and financial risks of unsustainability, what are called sustainability risks in EU terminology, requires a well-informed board, which in turn requires corporate sustainability due diligence across the business of the company. The benefits go beyond risk management. Sustainable value creation is gradually replacing shareholder primacy in a number of corporate governance codes, and perceptive board members will see that running a company well is about creating sustainable value. Concretely, a board can integrate sustainable value creation as an overarching purpose in the business models and strategies. A board must ensure that it has an adequate knowledge basis within the board itself and in senior executive management. The board should and partly must, depending on the jurisdiction and the size of the company and so on, undertake corporate sustainability due diligence across the business of the company, which includes the global value chains, as a key tool. This includes open and participatory processes. The sources for due diligence should include international, European, and other relevant rules and norms, sets of social norms recognized as best practice standards, such as the UNGPs and the guidance under the OECD guidelines, and draw on sustainability research. That's taking it seriously. As I've already alluded to, the results of the due diligence are crucial to the duties of the board on several points. The board must, as a matter of law, rectify a lack of legal compliance across the business. Facilitating or allowing a continued violation of relevant laws is against any meaningful understanding of board duties and is an excellent basis for a lawsuit against the board members individually. The board should recalibrate risk management accordingly, ensuring that it has a proper process for identification of risks, mitigation of risks, and adaptation to risks that cannot be mitigated, which depends on the size and the position of the company, amongst other things. The board can and partly should, and can be argued also in some cases must, make changes in the business model and set strategies to shift towards sustainable value creation. The board can and should, and perhaps also must, draw up an ambitious continuous improvement plan to follow up on the issues that it has identified through its corporate sustainability due diligence. The board can and should, and increasingly must, and again depending on the jurisdiction and the size of the company and so on, make sure that its corporate sustainability reporting is meaningful and is aligned with its financial accounting. These must mirror each other to make sense. The board should make sure that an assurance is undertaken of its corporate sustainability due diligence directive and of its corporate sustainability due diligence, not the directive itself, of course, and of the selection of issues for its ambitious continuous improvement plan. A smart board ensures that it also has auditing of the reporting on these issues in the continuous improvement plan. Doing this are key steps to mitigate sustainability risks and create sustainable value. This isn't only good for the company and for those affected by the business of the company, it also is good for the shareholders and other investors of the company because it is the basis for good returns also in the long term. And if the investors don't realize that and exert pressure on the board to continue with unsustainable business as usual to maximize returns, well-informed board members will stand their ground and do their job properly. They are not supposed to take instructions from individual shareholders. They risk being held personally liable if they don't do their job properly. By standing their ground, there is a risk that board members may be replaced at the next general meeting of shareholders. There is a possibility that they may then be offered a board position in one of the many companies that realize that sustainable value creation is the way forward. Whatever the case may be, board members that stand their ground and do their jobs properly based on proper information and a recognition of the changing times we are in can look at themselves in the mirror with confidence and calm, knowing that they have acted with integrity and in line with the law. And they can meet questions from future employers and future business partners and their own family and friends and respond, I stood firm, I did my job well, and I did my bit to contribute to a safe and just world. Here are a couple of further readings if you're interested in learning more. And this is work that we will continue doing in the research group Sustainability Law. We welcome you to follow our work and engage with us. And I thank you very much for listening.